Cryptocurrency holdings of significant value, especially Bitcoin, expose owners to unique risks, market volatility, regulatory uncertainty, custody threats, and succession chaos. A trust structure can isolate the asset, anchor it in clear legal ownership, and ensure orderly transfer to heirs or beneficiaries. When structured correctly, a trust holding Bitcoin or other digital assets minimizes tax surprises, protects against creditor claims, and clarifies governance, all while respecting French law's evolving crypto framework. Before locking crypto into a trust, you should understand how French law treats digital assets and fiduciary ownership. The answer is yes. French courts and tax authorities now treat cryptocurrencies as assets with economic value. A trust, whether a traditional fiduciary or a civil law structure, can hold Bitcoin on behalf of beneficiaries. The key is clear documentation proving the trustee's fiduciary capacity, not personal ownership. Beneficial ownership is paramount. The tax authority looks through the trust to identify who ultimately controls or benefits from the Bitcoin. If a settlor creates a trust but retains de facto control or enjoyment, the asset remains taxable in their hands. Transparent trustee governance and clear beneficiary designation prevent recharacterization. Heirs may dispute who owns the Bitcoin, creditors may claim it is still the settlor's asset, and tax authorities may deny the trust's legal effect entirely. A trust holding €1 million in Bitcoin without clear title, transfer records, or trustee mandates becomes contested and may be unwound in court or assessment proceedings. The answer is yes, but with caveats. French law permits both residents and non-residents to be settlers, trustees, or beneficiaries. However, a trust with a French beneficiary or asset in France may trigger French succession or wealth taxes, and a non-resident settler using a foreign trust structure may face scrutiny on whether French mandatory law applies. Owning Bitcoin is owning a private key. A trust must clarify custody and protect against loss or mismanagement. Direct key custody by the trustee offers maximum control but carries operational risk, loss, theft, or technical error. Delegating to a professional custodian, a regulated crypto asset service provider, transfers custody risk to them but adds cost and third-party dependency. The trust deed should specify the model and name the custodian explicitly. This is a critical gap. If a sole trustee dies and the private keys are known only to them, beneficiaries may lose access permanently. The trust deed must provide for successor trustees, escrow arrangements, or multi-signature wallets, so that no single individual's incapacity blocks access. Some settlers use time-locked key release mechanisms or cryptographic recovery vaults. Blockchain records are public. The trust deed should reference the specific wallet address holding the Bitcoin and authorize periodic audits. For example, signed messages from the private key, third-party verification, or custodian attestations. Without this, a beneficiary cannot verify that the trustee has not sold or diverted the asset. Insurance, multi-signature arrangements, and custody diversification all help. A trust holding €1 million in Bitcoin should mandate insurance covering theft or unauthorized access, require multi-signature authorization for any movement of funds, and prohibit holding the entire amount in a single wallet or with a single custodian. A trust that is invisible to authorities invites audit and denial. One that is fully transparent often attracts lower risk. French residents holding Bitcoin directly must report it on their annual tax return. A settler who creates a trust should declare the transfer of assets to the trust and identify themselves as the settler. Trustees managing trust assets in France must maintain accounting records and may owe corporate income tax if the trust is deemed to be a separate taxable entity. The trust should be transparent in its governance. The trust deed specifies that the trustee holds legal title for the exclusive benefit of named beneficiaries, and the trustee has no beneficial interest. French tax law treats some trusts as fiscally transparent. The beneficiaries are taxed directly on their share, but this depends on the type of trust and the beneficiary's status. The trust deed itself is the primary evidence, but supporting records matter. A signed transfer instruction moving Bitcoin from the settler's wallet to the trust's wallet, dated and recorded. The trustee's acknowledgement of receipt, and proof that the settler has not accessed, directed, or benefited from the Bitcoin afterward. If the trustee has professional status, for example, a corporate trustee, or if the trust holds assets generating income, yes. Many trusts holding static Bitcoin assets, not generating rental income or dividends, have minimal tax reporting obligations. But the trustee should confirm this with French Tax Council to avoid surprise assessments. A trust's core purpose is orderly transfer. For a €1 million Bitcoin holding, clarity is survival. The trust deed specifies who inherits the Bitcoin upon the beneficiary's death, the named secondary beneficiary or the beneficiary's own heirs. This avoids the default rules of forced heirship and allows the settler to direct the asset outside the estate, saving time and legal fees. Under French law, certain trusts can include provisions favoring grandchildren or more distant heirs, but forced heirship rules still apply to direct descendants. A trust holding Bitcoin for a settler's own children may not easily disinherit the children in favor of grandchildren without triggering a challenge. Legal advice on the specific family structure is essential. This depends on the trust type. If the trust is a true asset protection trust, fiducie sûreté or fiducie gestion, the Bitcoin is isolated from the beneficiary's creditors and generally cannot be seized. If the trust is revocable or the beneficiary has unfettered control, a bankruptcy trustee may reach the asset. The trust should specify whether the trustee may sell Bitcoin to rebalance the portfolio, take profits or de-risk, or whether the trustee must hold the full amount until beneficiary distribution. A trust that locks the trustee into holding depreciating Bitcoin for decades may breed conflict. Clear guidance on market downturns and remedial action prevents disputes. Protecting €1 million in Bitcoin within a trust is legal under French law. If the trust is documented, the trustee's role is clear, custody is secure, and beneficial ownership is transparent to tax authorities. The trust deed should specify the trustee's powers, custody arrangements, direct key holding or professional custodian, successor trustees to managing capacity, and beneficiaries' rights on death or disability. Tax compliance is simplified by treating the trust as transparent, beneficiaries taxed directly, rather than as a separate entity, and by filing any required disclosures, identification of settler, acknowledgement of transfer, asset holding statements. Finally, the trust prevents contested succession and can shield the Bitcoin from creditors if structured as an asset protection vehicle. With clear drafting and proper execution, a trust transforms a volatile, ownership ambiguous digital asset into a secure, inheritable holding aligned with French law.